Hi everyone, thank you for watching the Fortis Law short video series. My name is Patrick Tan, CEO and founder of Fortis Law. In this video, I will be talking about what happens if your company has debts and it has been threatened with winding up proceedings by its creditors. As you are aware, the circuit breaker measures announced by the Singapore government lately have curtailed everyone's movements and interactions with one another. This will undoubtedly impact and affect many areas in one's life. During this period of the circuit breaker, there could be some of you out there with a financially distressed company and facing winding up proceedings by the creditors. Before the COVID-19 pandemic, if a company has debts exceeding $10,000 and is served with this document called a statutory demand by this creditor, it has to pay the debt within 3 weeks, failing which the creditor could commence winding up proceedings against your company. The question now is whether, given the current COVID-19 situation, your company has any form of relief provided by the law. Well, the answer is yes. There is a form of limited relief provided by the COVID-19 Temporary Measures Act. What the COVID-19 Act does is that during the prescribed period of 20th April 2020 to 19 October 2020, it changes the sections in the Companies Act, where the thresholds for commencement of winding up proceedings against companies have been spelled out. For example, previously, the threshold for commencing winding up proceedings against a company under the Companies Act was a debt exceeding $10,000. It has now been changed to $100,000. Also, the previous prescribed period for the company to make payment of the debt is 3 weeks, but this has now been extended to 6 months. As a result of these changes, it has now become more difficult for creditors to commence winding up proceedings against a company. Furthermore, companies are also given a longer period of time to repay its debts to the creditors. Bear in mind that these changes to the Companies Act made by the COVID-19 Act only applies during the prescribed period, which is between 20th April 2020 to 19 October 2020. Assuming that there is no extension, there is nothing to stop the creditor after the prescribed period ends from issuing a statutory demand based on the pre-COVID-19 thresholds. That is for a debt exceeding $10,000 and the company is to repay the debt within 3 weeks. Well, I hope you found this information useful and informative. Thank you for watching this video. If you have a query or require some assistance in relation to anything which I have covered in this video, please do not hesitate to get in touch with my law firm. For more videos and updates on upcoming webinars, please subscribe to my law firm's YouTube channel and follow us on our Facebook and LinkedIn page. Stay safe, everyone.